38 days into the government shutdown, this morning a federal judge accusing the White House of withholding federal food assistance for political reasons and ordering the administration to fully distribute SNAP benefits by today. Judge John McConnell saying, quote, "People have gone without for too long. Not making payments to them for even another day is simply unacceptable." Vice President J.D. Vance arguing it's not up to the courts to decide.
In the midst of a shutdown, we can't have a federal court telling the president how he has to triage the situation.
Just days ago, the administration had agreed to tap into more than $4.5 billion in emergency funding to partially fund SNAP, which 42 million Americans rely on. The White House insisted those payments would still go out. Even after the president posted on social media, SNAP benefits will be given only when the radical left Democrats open up government.
Day 38 of the government shutdown. And this morning, a federal judge did something that almost never happens in American law. He pointed to the president's own social media post as evidence that the executive branch was deliberately causing harm to its own citizens. Not allegedly causing harm, not potentially causing harm, causing irreparable harm. Those are precise legal words with a specific meaning. Irreparable harm means the damage cannot be undone by money later. It means people are suffering right now in ways that no court order after the fact can fix. It means children going to school hungry this morning. Elderly people on fixed incomes rationing their meals today. Food pantries turning people away because they have nothing left to give. And the evidence Judge John McConnell used to reach that conclusion was not from an investigation. It was not from a whistleblower. It was not from leaked documents. It was a social media post the President of the United States wrote himself. SNAP benefits will be given only when the radical left Democrats open up government. That is the President of the United States. In writing, publicly, explicitly conditioning food assistance for 42 million Americans on a political outcome he wanted, not on a legal determination, not on a funding question, on a political demand. The food goes out when I get what I want. That is what he wrote. That is what the judge read. That is what became the evidentiary foundation for a federal court finding of deliberate harm. Judge McConnell's words deserve to be read exactly as he wrote them. People have gone without for too long. Not making payments to them for even another day is simply unacceptable. Simply unacceptable. A federal judge appointed under the constitutional system of this country looked at what this administration was doing to the most vulnerable Americans and wrote those two words. Simply unacceptable. Not legally questionable. Not constitutionally complex. Simply unacceptable. And J.D. Vance went on television and said courts cannot tell the president what to do during a shutdown. We need to talk about that, because that argument is more dangerous than the shutdown itself. But before we go any further, real quick, let's be honest. You can't really trust mainstream media anymore. That's why we built Pump Politics, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us. Be part of the community that actually cares about the truth. All right, let's get back to the video. Let's establish the precise sequence of events here, because the chronology matters enormously, and the mainstream coverage keeps collapsing it into a simple shutdown story when what actually happened is significantly more specific and significantly more disturbing. SNAP, the Supplemental Nutrition Assistance Program. 42 million Americans depend on it, not as a supplement to comfortable lives, as the difference between eating and not eating. These are the lowest income households in the country. Working families whose wages do not cover basic expenses, elderly people on fixed Social Security incomes, disabled Americans whose medical costs consume most of what they have, single parents working multiple jobs who still cannot make the math work without assistance at the end of the month. The government shut down. Day 1, Day 10, Day 20, Day 38, the longest shutdown in American history. The previous record was 35 days. Set during Trump's first term in 2018 and 2019. This one broke that record and kept going. During the shutdown, the administration had a legal obligation. SNAP benefits are established by federal statute. They are not discretionary. Congress created the program. Congress funded it. The administration's job is to distribute the money Congress allocated to the people Congress said should receive it. That is not a political decision. That is a ministerial function. The administration administers the law Congress passed. Several days before Judge McConnell's order, the administration had agreed to tap into more than $4.5 billion in emergency contingency funding to partially distribute SNAP benefits. That agreement was an acknowledgement of two things simultaneously. First, that the legal obligation to distribute benefits existed and was real. Second, that the mechanism and the money to meet that obligation were available. They had the authority. They had the money. They agreed to use both. And then Trump posted on social media, SNAP benefits will be given only when the radical left Democrats open up government. That post changed everything, because it was no longer possible to argue that the administration was withholding benefits because of technical funding constraints or legal complexity or logistical challenges. The president had stated his reason publicly. The food was being withheld as a negotiating tactic, as political leverage, as a hostage situation where 42 million Americans were the hostages and reopening the government on Trump's terms was the ransom. Judge McConnell read the post. He read the evidence of harm. He reviewed the administration's conduct against the backdrop of that post, and he issued his order. Distribute the benefits. Today, not tomorrow. Today. Because not making payments to them for even another day is simply unacceptable. The administration announced it would appeal. Now let's talk about what J.D. Vance said on television. Because I want to be precise about this and I want to be fair about it before I explain why it should alarm every American, regardless of their political views. Vance's argument has a kernel of legitimate constitutional complexity inside it. During a government shutdown, the executive branch genuinely does face resource constraints and triage decisions. Not every program can be fully funded simultaneously when appropriations have lapsed. The president does have some discretionary authority over how to manage a funding crisis in the short term. These are not invented arguments. They reflect real tensions in how the Constitution allocates power between the branches. That is the legitimate version of what Vance was saying. Here is where it breaks down completely. The president's discretion to triage during a funding crisis does not include the discretion to publicly announce he is withholding legally obligated benefits as a political bargaining chip and then argue that courts cannot review that decision. Those are two entirely different things. Triage means making hard choices about limited resources when you have to. What Trump did was announce on social media that he was making a political choice about unlimited resources that were specifically available and specifically allocated for this purpose. The $4.5 billion in emergency contingency funding existed. The administration had already agreed to use it. The money was there. The authority was there. The agreement to use both was already in place. And then the president posted that the money would not go out until he got what he wanted politically. That is not triage. That is coercion. And Vance's argument that courts cannot review it is not a constitutional position. It is an assertion that the executive branch can use the basic survival needs of 42 million Americans as political leverage without any judicial check whatsoever. Here is why that argument is more dangerous than this particular shutdown. If the court accepts that argument, it means the next president, and the one after that, and every president for the rest of American history can withhold any federal benefit from any group of Americans during any funding dispute, and no court can stop them. Social Security, Medicare, veterans' benefits, disability payments. All of it becomes potential leverage in any political standoff where one party controls the White House and the other controls Congress. The constitutional guardrail against that is judicial review. The ability of federal courts to say the executive branch has exceeded its lawful authority and must stop. That is what Judge McConnell did. That is why Vance's argument that courts cannot do that is so significant. It is not just a defense of this administration's conduct in this shutdown. It is a claim that this entire category of executive action is beyond judicial review. Forever. For anyone. Judge McConnell disagreed. The evidence shows that people will go hungry, food pantries will be overburdened, and needless suffering will occur. Courts exist precisely to make that kind of finding and order it stopped. That is the system working as designed. Let's talk about the human geography of this shutdown, because the numbers tell a story that the political coverage consistently buries under procedural details. 42 million Americans depend on SNAP. To put that in context, that is more people than live in California. It is more than the combined population of 25 individual American states. It is not a small program serving a marginal population. It is a foundational part of how the bottom quarter of the American income distribution survives every single month. These are not people with savings accounts to draw on while they wait for benefits to resume. These are not people who can put the extra expense on a credit card and sort it out later. For millions of SNAP recipients, the monthly benefit is the difference between the family eating in the last week of the month or not eating. When those benefits do not arrive, people do not eat less. They do not eat. The food pantries. Every time SNAP benefits are disrupted, the overflow goes to food banks and food pantries, organizations that operate on donated food and volunteer labor, organizations that were already stretched before the shutdown because food insecurity in America was already at crisis levels before day one of this budget standoff. Judge McConnell found explicitly that food pantries will be overburdened, not might be, will be. The evidence before him established it as a certainty. Federal workers, hundreds of thousands of government employees going without paychecks, the people who keep the systems running that Americans depend on every day, air traffic controllers, TSA agents, Border Patrol, scientists, researchers, public health workers, going without pay while continuing to show up and do their jobs because the law requires it and because the work matters. Every day without a paycheck is a family choosing between the mortgage and the groceries. Every day is a retirement account going unfunded. Every day is a debt accumulating that will take months to pay down even after the shutdown ends. And then there are the members of Congress. The House of Representatives has been out of town and out of session for 49 days. 49 days since they passed a budget or failed to. 49 days of being home, giving speeches, attending fundraisers, meeting with donors. Not in Washington, not in session, not doing the one job that the Constitution specifically gives them that no one else can do. Pass appropriations, fund the government, and every 2 weeks the direct deposits arrive. Full salary, no interruption, no penalty, no consequence of any kind for the failure that produced this crisis. The 27th Amendment prohibits changing congressional pay during a term. That is the law. Members cannot be docked their salary by statute. But there is no law requiring them to keep it. There is no requirement that they accept their full pay while their constituents line up at food pantries. They are choosing to, every one of them, from both parties. That choice is a statement about priorities that requires no interpretation. Let's be precise about what this moment actually means, because underneath the daily noise of shutdown coverage, 4 facts define exactly what is happening and what it will mean going forward. Point number 1. The President of the United States used his own public words to prove in federal court that he was deliberately causing harm to 42 million Americans. This did not require investigation. It did not require whistleblowers or leaked documents or anonymous sources. Judge McConnell pointed to a social media post Trump wrote voluntarily and publicly. SNAP benefits will be given only when the radical left Democrats open up government. That sentence, written by the president himself, established the administration's intent. Not funding constraints, not legal complexity, political coercion. The judge found it. The evidence was the president's own words. In writing, time-stamped, publicly posted for anyone to read. This is what accountability looks like when it works. Not a political attack, not a partisan accusation. A federal judge reading a president's own statement and finding in it the proof of deliberate harm to the people that same president is constitutionally obligated to serve. Point number 2. The $4.5 billion existed. The authority to use it existed. The administration had already agreed to use it. And then the president posted on social media that it would not be used until he got what he wanted politically. This is the detail that the coverage keeps underplaying. This was not a case where the administration lacked the money or the legal authority to distribute benefits. They had both. They had agreed to use both. The decision to withhold benefits after that agreement was not a resource constraint decision. It was a deliberate reversal of an existing commitment made for explicitly stated political reasons. The judge found that the administration defied his court order. Defied. Not failed to comply due to logistical challenges. Defied. That is a finding of deliberate non-compliance with a judicial order by the executive branch. The implications of that finding for how the rule of law functions in this country extend far beyond the question of SNAP benefits. Point number 3. Vance's argument that courts cannot tell the president how to triage during a shutdown, if accepted, eliminates judicial review of executive conduct during any declared emergency or funding crisis. This is the argument that deserves the most attention and is getting the least. It is not a narrow legal position about SNAP specifically. It is a broad claim about the scope of executive power during funding disputes. If courts cannot review presidential decisions about which legally obligated programs to fund during a shutdown, then every benefit program in the federal government becomes a potential hostage in every future budget standoff. The courts have not accepted this argument. Judge McConnell explicitly rejected it by issuing his order, but the administration is appealing, and the appeal is not about SNAP. It is about whether the executive branch can use the suffering of vulnerable Americans as political leverage without judicial review. That question matters for every American regardless of whether they receive SNAP benefits. Point number 4. Day 38 is the longest government shutdown in American history, and the Senate has voted 14 times to reopen the government without resolution, 14 votes. The Senate has passed measures to reopen the government 14 times. The House has been out of session for 49 days. Members of Congress are still being paid. 42 million Americans are uncertain about food assistance. Federal workers are going without paychecks. And the president's stated position is that none of this changes until he gets what he wants politically. The previous record shutdown lasted 35 days. This one broke that record and kept going. The human cost of each additional day is measurable and real. More families going to food pantries, more federal workers falling behind on bills, more economic disruption rippling out from a government that has stopped functioning because one person decided that 42 million Americans' food assistance was an acceptable bargaining chip. So here is the bottom line. Day 38, the longest government shutdown in American history. A federal judge ordering the Trump administration to distribute SNAP benefits to 42 million Americans immediately, the judge finding irreparable harm. The evidence being the president's own public social media post explicitly conditioning food assistance on a political outcome. The judge's words precise and unambiguous. People have gone without for too long. Not making payments to them for even another day is simply unacceptable. The administration appealing. J.D. Vance arguing courts cannot tell the president how to manage a shutdown. The Senate voting for the 15th time to reopen the government. The House out of session for 49 days. Members of Congress still collecting their full paychecks. The Trump Tower penthouse was not 30,000 square feet. The social media post said, "SNAP benefits depend on Democrats reopening the government." Some facts do not require interpretation. They require only that someone read them and refuse to look away. 42 million Americans. That is more people than live in California. They did not create this crisis. They did not vote for this shutdown. They did not write the budgets that failed to pass or refuse the compromises that might have prevented this. They were going about their lives, and the government that is constitutionally obligated to administer the programs Congress created for them decided their food assistance was a useful piece of leverage in a political fight. A federal judge said no, in writing, citing the president's own words as evidence, finding irreparable harm, ordering compliance by the end of the day. The administration is appealing, and somewhere in this country right now, 42 million people are waiting to find out if they can feed their families. While the House of Representatives has been out of town for 49 days, and every member is still getting paid. The answer to what this is about is not complicated. The president wrote it himself. Stay with it, because this shutdown is not over, and the question of whether courts can stop a president from using hunger as a political weapon is going to be answered in the appeals process in ways that will define how American democracy functions for years to come.